Welcome to the third broadcast of the Town of the Ring of the Heavens. This is your host, Keith and Tony. Tony, say hello.
Hello, everyone.
All right, we've got a lot of information to cover tonight, so I guess we better get started. First thing, if we are talking about private membership associations or any titles, codes, or anything else, we do have to say that we are not a licensed attorney, and anything we say on here is not a substitute for any advice given to a licensed or by a licensed attorney. That being said, let's move on. All right. We were going to talk about today about the private membership associations and how they operate and what they were supposed to be doing. First of all, we need to recap a little bit on the second broadcast that we did on the 29th, I believe it was. So, what we were talking about was the United States being part of or being Manhattan Island, and that it was foreign to the states of the Union. And there's actually a lot of cases backing that, and it's been well established over and over again over a couple of hundred years. In many, many cases, we have that written in our First in Time, First in Right document. You can go see that, and there's a lot of proof in there. You can find that on the reignoftheheavens.com. The title is First in Time, First in Right, and there's cases in there that talk about it. After we did that episode last week, I went around and went to these websites and got screenshots in case they disappeared. And I do have a screenshot of the Organization of American States where it says in their address United States of America. I did get a screenshot of the Bank of New York Mellon and their headquarters and where it says United States and their address. And I also got a screenshot of global citizenship and sustainability, where the global citizenship is being pushed and implemented by the Bank of New York Mellon itself. Well, why would a bank be worried about citizenship, right? Doesn't make any sense.
Nope.
So, and I also, when I went into their some of their archives, I got some screenshots where it says United States of America on a national currency, and that's Manhattan Island's national currency. That has nothing to do with the states of the Union. And I did a little research on Alexander Hamilton, who started the Bank of New York, which was in 1784. It was a year after the peace treaty was signed with the 1789 Constitution. Now, let me say that again so everybody possibly have missed what I just said. I did a little research on Alexander Hamilton, which, by the way, is referred to as an American prophet by the Bank of New York Mellon. And he started the Bank of New York in 1784 after the 1783 Treaty of Paris, the peace treaty that made a treaty with the 1789 Constitution. So in 1783, there was a peace treaty with the Constitution that did not exist for another 6 years. That tells you a lot. Now, in 1786, at the suggestion of either Nathaniel Bormann, then president of the Continental Congress, or Friedrich Wilhelm von Steuben, the Prussian general who served in the Continental Army, Hamilton invited, this is Alexander Hamilton, the same old guy, okay? He invited Prince Henry of Prussia to become president. Now, if they hadn't gone to a constitutional convention yet, being president of what? That was the whole thing, because remember, the style of the Articles of Confederation was the United States of America. Uppercase T on the United States of America. Go look it up. You can go, anybody can find it. However, this guy Hamilton invited Prince Henry of Prussia to become president or king of the United States. But the offer was revoked before the prince could make a reply. Now, this is going to go into the type of republic it became, which most people believe, the majority of people believe, they want their republic back. And their definition of a republic is that the people are the independents. In other words, the people are the voters and they're in charge. But they get it confused because the type of republic you have is just an absence of a king, where they made a president who rules under executive order. So a very few people of the United States created a constitution for the United States of America, which they had no authority to do. And it's very clear that they wanted a king. So since George Washington was a cousin of the monarchs, they put him in there and then heralded him for giving up his kingship and becoming president, as if it was some kind of humble move that he was doing. When there's no difference between there was no difference between that type of a republic or a king. And this, now, most of the people will say, well, who are the people on Manhattan Island? Okay. Well, we can go all the way back to Alexander Hamilton, who started the Bank of New York Mellon, which basically right now kind of runs everything today. That's what they run, all the courts, they run everything, and that's why the people are blaming the Federal Reserve. But the Federal Reserve is just a subdivision of the Bank of New York Mellon. There's no difference between them. Now, Alexander Hamilton was born and spent part of his childhood in Charlestown, the capital of the island of Nevis and the Leeward Islands. That's in the Caribbean. The Nevis was one of the British West Indies. Hamilton and his older brother, James Jr., were born out of wedlock by Rachel Fawcett, a married woman of partial British and partial French Huguenot descent, and James A. Hamilton, the fourth son of Scottish laird Alexander Hamilton of Grange, Ayrshire. So I'm just going to read just a little bit so you'll understand what's happening here. It is not certain whether the year of Hamilton's birth was 1757 or 1755. The most historical evidence after Hamilton's arrival in North America supports the idea that he was born in 1757, and many historians have accepted his birth date. But his early life in the Caribbean was recorded in documents which were first published in Danish in 1930. Okay, so Hamilton was a Dutchman. Everyone in the United States who is anybody has Dutch descendants. They're all the Dutch, which is very closely tied to the Netherlands today and the King Willem. So the monarchs never left. They just made it appear as if you had independence. And they told everybody you have the Bill of Rights and all these things, not really telling them what the truth was, that they really did. And we're not, crapping all over the Constitution everybody seems to worship. We're just bringing out the facts here. Now, what they did was the monarchs set this up in a real cunning situation to where people believe that they're free. Okay? And they left the basic freedoms in a real specific area, and they're called private membership associations. And private membership associations are inherently dealing with private contracts between people. So it can be an unincorporated association, or it can be an incorporated association, which is a 501c3, of which all the courts today are 501c3s. They're private membership associations, just like the Bar Association. That's a PMA. When I say private membership association, I'll just say PMA. It's easier to say. All of the AAMVA, that's a National Drivers Association, your driver's license, your DMV, they're all private membership associations. They all run on their own contracts. So when you hear somebody say, well, our policy is this, this, and this, the reason why their policy overrides public law, state statutes, and federal laws is because it's a private membership association, or a PMA. Now, where they hid the remedy for no jurisdiction is they hid it in for plaintiffs and defendants in that capacity, and they put it in the U.S. Code, which was Title 28, Rule 17. You can read all three paragraphs. There's A, B, and C. But the one that applies to private membership associations would be B. So it would be Rule 17B. And this is the capacity to sue or be sued. The capacity of an individual other than the one acting in a representative capacity, I'm saying this as a quote, to sue or be sued shall be determined by the law of the individual's domicile. Let me read that again. The capacity of an individual other than one acting in the representative capacity to sue or be sued shall be determined by the law of the individual's domicile. If you have a private membership association that has declared domicile in a particular state, you determine whether you have the capacity to sue or be sued or not. And when they say by the law of the individual's domicile, okay, the capacity of a corporation to sue or be sued shall be determined by the law under which it was organized. That's its constitution. In all other cases, capacity to sue or be sued shall be determined by the law of the applicable state, except that a partnership or other unincorporated association which has no capacity by the law of its state may sue or be sued in its common name for the purpose of enforcing for or against a substantive right existing under the Constitution or laws of the United States. I'll read that again. That a partnership or other unincorporated association which has no capacity by the law of its state may sue or be sued in its common name for the purpose of enforcing for or against its substantive right existing under the Constitution or the laws of the United States. So only an association, partnership, or something like that has the authority or would have a substantive right existing under the Constitution or the laws of the United States. Now, we go over to Amendment 14. Everybody says I'm not a 14th Amendment citizen. That's not what that means. Okay, as far as we understand it. Okay, the 14th Amendment. And now that you understand about all the monarchs, you're going to understand what this is actually saying. The 14th Amendment was under Reconstruction Amendments, and the reason why this came out, because at the time the 14th Amendment came in, the states had all, North Carolina, I think it was either North or South Carolina, had left the original Union under the United States of America, 1781, the original Articles of Confederation, and blew everything up. Okay, so there was a big old civil war, it was a big mess and everything. Now this really messed with the monarch's business over here. The monarchs we're talking about would be the Netherlands through the United States. You have the Queen, you have France. They split the country in two and divided it among themselves and decided that they're going to be doing business here. But if there was going to be another big blow up, they did not want the states to be able to mess around with their business, making laws just like they did during, I think it was South Carolina, that seceded from the original Union. So since that was the case, they had to go in and do an equal protection clause, which requires each state to provide equal protection under the law of all people within its jurisdiction. They had to put that kind of stuff in there. Then it says the second, third, and fourth sections of the amendment are seldom litigated. However, the second section's reference to rebellion and or other crime has been revoked as a constitutional ground for felony disenfranchisements. That would protect the monarch's business, especially if the monarchs put all of their businesses in private membership association. So it says all persons born or naturalized in the United States. Now, persons, we're still talking about artificial entities. Your person, okay? If that person was born and naturalized in the United States, subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. No state shall make or enforce, listen, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Now, a person and or a citizen of the United States can also be a private membership association, or a PMA. So what the monarchs did was they made sure that the states did not make any laws or anything that would deprive a person being able to contract, or people being able to contract through their persons.
Nice little loophole.
A little bit of a loophole. So essentially, when they split the country in two, which was a private and a public venue, they created two venues. One's private, one's public. When people go to the private and they contract to themselves, that's the law there in the private. No state can come in and enforce any statutes on you, nor can any federal enforce any statutes on you. Nothing. They have zero jurisdiction. So if you have alternative energy machine that you would like to sell to your members, you can do that. And you can even advertise. Being private does not mean you can't advertise. If you are a private membership association, you can advertise what you do as long as you only sell it to members under contract. Even if they come in and say that you're doing something this or that, they have to prove nefarious act through due process, which means they have to go through discovery, and they have to, through discovery, establish some kind of nefarious act or danger that you're doing. It's a danger to the public. So if people want to go through and look at these things, they can look at the 14th Amendment, the Fifth Amendment. That's the Due Process Clause, and then the First Amendment, which is the right of association. In there, they call it assembly, right? But they determined in the U.S. Supreme Court that it would be the assembly also meant right of association. Am I correct on that?
That's right. And one of the famous cases, or the famous case, is Marbury versus Madison. That's where they decided that to peaceably assemble means to also be a part of an association.
Okay. So in an association, you have a constitution and bylaws. In your bylaws, you determine the law of your association. The members are voting members. You can have a president, vice president, treasurer, and secretary. And everyone gets together, and everyone's trying to change everybody else in this country, if you've noticed. However, they don't realize that they can have their own constitution and bylaws and do their own thing. And this is what you do to dissolve or get around mob rule. So say they, in your association, you don't agree with same-sex marriage. If you don't agree with that, that's cool. In your association, you do not have to serve that cause. And you can't be sued by it because they're not members. It's in your contracts and bylaws. So if you sell wedding cakes, and I've heard of a bunch of cases like this. I've heard 3 of them, but I'm sure there's more, where the individual was making a cake and they didn't agree with what was going on, and they were sued for it. It's because they were serving the public. If they had operated as a private membership association, they can only sell cakes to members, and they can pick and choose who becomes a member.
That's right.
And they're completely immune from any state or federal statutes, as long as they're not doing anything nefarious, meaning their cakes are poisoning people or killing people, or they're beating up people that they don't agree with. Okay, that's different. That would be a public crime, and you would lose that bail. But saying no is not beating anyone up. It's not hurting anyone. It just means that they only serve their members. And within your association, you can put in your bylaws as for religious beliefs. Okay, so now you're free from all these things, these liabilities that you have, or you believe that you would have for agreeing with that type of or having to serve that type of activity that you just can't consciously serve. We get it, we understand it, but that's how you deal with this. Also, this works very well with CPS cases, Child Protective Service cases, because essentially the family is an unincorporated private membership association, PMA. Believe it or not. And you can put in your minutes, you can put in your bylaws that all you have a laundry room. Okay, so that would be called laundry services. You have a medicine cabinet, that's medical services in your private membership association. You have a kitchen, so that would be your cafeteria services. Anything else, Tony?
Yeah, not to mention you have the rules of the house, which essentially are terms and conditions of the private membership association.
Bylaws.
Mm-hmm.
You put those in your bylaws. You can offer, your association can offer birth certificates to your children. You don't have to go under state birth certificates. State birth certificates bring you into the state's private membership associations, the King's Business.
Which brings me to another a point on private membership associations, is that they don't have to be registered anywhere.
That's correct. If you would like to take an existing entity and turn it into a private membership association, all you have to do is put a legal notice in the newspaper. Blah Blah LLC now does business as a private membership association. It's that simple. It's about $150 or $200, whatever it is. Some are $80. And you give its address on there, and that's it. You have the publication. Now you can use that as a private membership association. And now all your customers have to become members. And once again, the members cannot sue the private membership association, because the private membership association can operate as a private arbitrator. It can have an arbitrations section of its business where you go to arbitration and settle disputes. Customer dissatisfaction, all these kinds of things.
You can have a board of peaceful settlement of disputes.
Mm-hmm. So essentially, under Rule 17b, you can get pretty much every case dismissed. Any state that has ever gone after a private membership association has lost. Hands down. Not one time has the state ever won against the PMA. They simply don't have jurisdiction, guys. And this is what they call the biggest legal secret in the country. Matter of fact, the Reign of the Heavens, town of the Reign of the Heavens, goes by this. Towns are a lot of the same thing. They're either unincorporated, which are PMAs, or they're incorporated PMAs. They can also be PMAs that way. Every resident becomes a member and or a citizen of the town. What you'll notice that we found, this was funny, we found in, what was that town called? Center Hill Township? Or Center Hill, yeah. City of Center Hill?
That's right. Yep.
Yeah, they took it a step further. Where they put in 1986, they put in their charter that the members could vote them in themselves. So the board, the city council, made it to where they could vote in their own city council, bypassing a popular vote within the city limits. Yeah, and that's illegal. Can't do that. That is slavery, and that's what they call nefarious act. So as of right now, the city of Center Hill is operating illegally. They have a slave camp over there. We found a lot of that in a lot of the cities. The citizens are not everybody in there, or everybody that lives within the city limits, which is slavery. So not everyone has a vote.
You might want to start looking into your charters.
Yeah, take a look at the charters. They're incredible. They have a lot of stuff in there. I think there was one city of Baltimore where the city of Baltimore is literally the mayor, the city council, and I think it's the secretary or something like that. That's the whole city. They own that. Those offices own the whole city. It's illegal. Can't do that. But nobody knows anything about charters. And private membership associations are very difficult to understand for most people. So we do have a link to Constitution and bylaws that will be provided, and that's on the front page of the free conference call wall. It's down on the bottom right. You can go in there and take a look. We do have some available there. And the more people that know about this, the more associations that are going to pop up and start helping others in their associations and getting them set up that way.
Even associations can join other associations.
Exactly, and they call them associates. They call them associates, believe it or not. Is that association associated with this association? And it goes on and on and on.
Right. Yep.
I believe there was a type of audit that was done, and they found, and this was in the citizens of the United States, those guys, the real ones that actually took an oath and affirmation to it, and the bloodlines that go down through the time, most of them are Dutch. I think they had 6,000 or 7,000 associations within one corporation that they were operating. So the corporation owned the associations. So it's a nightmare to try to sue them.
Mm-hmm.
And anybody that doesn't know about the association, like the general public that doesn't know about them, it appears as if it's illegal and corrupt, but you just don't understand what they're doing. And since lawyers deal with nothing but entities, they understand it very well because they're trained in it.
And they're part of, the bar association.
Right. And they've gone through that, so now they know that they're a part of a private membership association.
Yep.
So the difference between a PMA court and a court of public record, a private membership association that operates as a 501c3, like a regular court. If you don't believe us, you can just go on to Dun & Bradstreet and go find out. They operate as private company 501c3s. It's all there. It's easy to find. I'm going to give you a comparison on how a court of public record is supposed to operate, or does operate, and how a PMA operates as a private court. There's a big difference between them. So the only way to do that is to go through a process of how a human rights tribunal, a national human rights tribunal, which is, if you go to humanrightstribunal.international, that's a court of public record. There's a lot of things that it does. It operates in a very unique way because it does it the way it's supposed to be done. And I'll give you an example. Okay? Now, we're dealing in artificial entities here, so let's go with let's get away from because usually the audience that we're talking to deals with I'm a living being and all that. We're going to set all that aside, and we're going to deal with simply entities. An artificial entity, an idea that was put on paper, and this is how it operates, and it was established, and it's supposed to serve the general public or serve its members. And how does it benefit its members? So the very first thing on a human rights tribunal, in the first hearing that's ever heard, anything in any case, is you establish a record. The record being how the Human Rights Tribunal recognizes, for lack of a better term, the individual that's there in the court, that's making a claim. So does it recognize it as a private membership association? Does it recognize it as a person? The international entity that everybody uses, the all-cap name? That's the international entity, and you can define that any way you want, by the way. You don't have to get rid of it. You can just define it in a different way. It can do business as an LLC. It can do business as a PMA. It can do business as a international corporation. It can do business as a sovereign entity. It can do a business as anything. It just has to have the Constitution and bylaws. So you have to establish a record. So does the PMA have, is it located, is it a NAC? Does it have a natural area code address? Does it have a federal address? Does it have an international address? That kind of thing. And you establish that person. Okay, so we're establishing how the Human Rights Tribunal recognizes the individual that's standing before it. Okay? The second thing that happens is there's an interview process to clear the victim. Now, internationally, it works differently because people are used to the private membership association courts operating the way they operate. They don't realize how they're literally supposed to operate. So we'll give you an example. A woman calls rape. Okay, this individual raped me. Okay, so she goes through what they call a interview process. And it's usually done with an officer, could be a human rights defender, that will go through an interview process to find out what is going on, what's happening, get the details of the case and everything else. Once we know and a record has been established that the Human Rights Tribunal has jurisdiction over the individual. And if it doesn't, by the way, I forgot to say this, you can write a grant of jurisdiction to the Human Rights Tribunal, the grant jurisdiction over your case. And then what we do is an interview process to clear the victim. See, the one thing that people don't do, especially in a criminal case, is a lot of the victims of the criminal cases are never cleared. So it allows for the defense attorneys to badger the hell out of them when they're and trip them up and make them mad to get their client off. That's all that happens. So if they're cleared, the defense cannot write questions that try the victim. If they do that, it becomes double jeopardy. Does that make sense, Tony?
Yep, sure does.
Okay, so the second hearing in a human rights tribunal process is clearing the victim. We have to have the interview process. A human rights defender comes up and says, yes, I interviewed them. This is what it looks like, and it looks like that this individual is cleared of all wrongdoing. We have nothing to say to them about them. In other words, whatever they're saying it appears to be true, or we didn't see any provocation on the side of the victim, the one that's making the accusation. So the victim's walking down the street, purse gets snatched, gets beat up, or something like that. Did that individual do anything to provoke anybody, or yell at people, or were they cussing them out? Did they start it? That kind of thing. Okay, I'm just trying to give you a gist of what that means as far as clearing the victim. Now, there's an affidavit after that. The next process is an affidavit is filed for case validity, meaning what happened. We want to know the facts. The Human Rights Tribunal wants to know the facts. They want to know what's going on through affidavit, and they want to be able to hold your feet to the fire. Meaning, if you sign this, you sign it under perjury, and then you have a notary sign it. And now we know that you're serious. Okay? And that affidavit is filed and then served on all parties. And then we wait. It's served once. After 10 days, it's served again. And after 21 days, it's served again. And if there's nothing there, usually after 30 days, the clerk will come back. If nothing comes back, the clerk will come back and set a date. Now, during this hearing, okay, the tribunal, what they do is they declare or not declare whether human rights violations exist. That's all they're doing in some type of judgment. Now, if the individual, because there's certain circumstances on this, but if the individual did in fact suffer human rights violations, the Human Rights Tribunal declares that the human rights violations did in fact and do in fact exist. That's what it does. Now, what that does is it keeps the independence of the judiciary and the neutrality of the judiciary. The Human Rights Tribunal does not judge people. Judge not, lest you be judged. It doesn't judge people. All it does is it declares whether a human rights violation in fact exists. Does that make sense, Tony?
Yes, it does.
Okay? And you'll notice that we've done that quite a bit. If the human rights violations in fact exist, you get the three-judge panel. It's a three-judge, that's why they call it a tribunal, three. They declare that, in fact, by the affidavit and the facts, the other party never answered back of anything, then it's a free and clear deal. It goes all the way through and says, okay, the Human Rights Tribunal says, yes, human rights violations did in fact exist. Now you have a judgment. Now where do we go from there? Well, if the Human Rights Tribunal, if in fact exists, then the judgment goes to the Treasury for value. That's where value is assessed. That's where damages are assessed. Once the value has been assessed and everything's been, there's a declared value of damages in the case, then it goes to the governor for executions. The governor executes it. The execution means that a judgment and lien has been filed against the perpetrators of the crimes. Now, there is no tribunal, court, anywhere in the world that can remove that type of judgment and assessment and process. They can't remove. It's almost well, actually, it is impossible to remove. So that is what the Human Rights Tribunal .international does. Spell out international. INTERNATIONAL. Spell out international. Human Rights Tribunal International. Okay? Anything else that we need to cover, Tony?
No, it's very clear and it's very simple.
Okay. Now, this is what happens in a PMA court, Private Membership Association court, one that operates as a 501c3. And we're going to get into what the United States Constitution is in just a few minutes. What happens is you go in there and you have a man judging another man, and he's saying, you guilty or not guilty? What do you plead? And then you say, not guilty. All right, court trial, 20 or 30 days, and, this is an arraignment, and his arraignment's done and all that, and good to go. Now, most judges, whether the juries, they have juries in there. Juries are not supposed to find whether you're guilty or not guilty. They're only supposed to declare whether the law has been broken or not. A judge is not supposed to assess a fine. He's only supposed to, in a jury trial, affirm that the law has been broken. But what they do there is he determines the law has been broken. He assesses the fine and the sentencing, which is not his job. That's the treasurer's job.
And the governor for the execution part.
That's right. Governor's supposed to sign off on all trials, because he's the one that signed it into law. Signed the law that was broken into law. Now, on a county level, the mayor's supposed to do it. He's the one in charge of the police. So it's supposed to go to the treasurer, and the mayor signs off on the execution. He goes and executes it. Whatever the assessment value is, whatever the fine is that's assessed by the treasurer, all that kind of thing. Every one of the cases that they have right now violates the independence of and neutrality of the judiciary. So usually, the treasurer is on the executive branch. So you have the judiciary reaching over into the executive branch and screwing around and doing the treasurer's job and doing the mayor's job. The judge is not supposed to do that. But since they have their own policies under their own 501c3 and their own rules and that override state law or a proper judicial process, that's how they get around it. It's very difficult to sue them because they are a PMA. The only reason why a judge has immunity is because it's under the 1st, 5th, and 14th Amendment. It has nothing to do with judicial immunity, because they operate as a private membership association. And he's the trustee or the president. Chief judge is usually the president of the PMA. Now, that being said, if anybody goes on to Dun & Bradstreet and or Manta, they can look up the Constitution of the United States. The Constitution of the United States is classified as two things. Number one, it's classified as a religious organization. And number two, it's classified as a private company, started in 1787. So what everyone believes is their federal government, in quotations, is nothing more than a religious organization, a church, operating as a private company. That's all it is. That's all it ever has been. And the reason why it operates that way is to protect the interest of the monarchs of Europe. I'll give you an example of how that's set up a little bit, just a little bit. The King of the Netherlands is pretty much the head of everything. The British King, or Queen of England, she's not, she's sovereign, but she's actually a subsidiary of the Netherlands. The Netherlands endorsed her crown. That's how they became kings and queens. So when they want to set up a monarch, they get the Netherlands to endorse their crowns.
And they just basically manage those.
Yeah. So that being said, that should give you something, a lot to chew on to help people understand what private membership associations, and by the way, the PMAs are is the information that every one of the Patriot groups is missing. They just didn't get it. They just didn't know it. They didn't know it was there. And every one of the study groups and everybody's missing that. So if you want to set one up, you got to set one up professionally, well organized, published, and/or incorporated, and you'll have what you want. It'll stop all these fights. Now, Rule 17b doesn't necessarily mean that the federal courts are actually going to dismiss the case. Okay, you really have to probably go through about 2 or 3 judges to make that happen, because honestly, they just don't do their job. They don't pay attention to anything they're doing. They're only told by what to do by what the district managers tell them what to do. So the district, say like the District of Minnesota, that has a district manager, and the district managers get paid. They have nothing to do with the courts. They're not even lawyers or judges. They get paid for convictions. They get bonuses and stuff. So you got to really get around that. So it's going to be a little bit of a fight, but in the end you'll win. In the end, it does happen. It's just going to be a little bit of a fight. Sometimes. If it's just frivolous and stupid, then they'll just let it go. Just dismiss it, and that's it. But if it's something that you're interfering with the king's business, then they'll probably come after you pretty hard. But still, in the end, you're going to win. Because if the king overrides his own law, he puts all of his businesses in jeopardy. Anything else that we need to cover, Tony?
Well, I don't know if you want to cover it now, but we can, or maybe next show, we can talk about if there's all these private membership associations, the courts, you have all these associations, and you're being forced into these associations. Do people know that they have the human right not to be forced into being a part of an association? And I don't know if that's something that we should go into later in more detail, or if you want to touch on that.
Let's make that the third. Let's do that on the next show. That's a good idea. We can go through the human rights, Universal Declaration of Human Rights, and show people where their rights are and how they can operate and protect themselves. It's another part of it.
Yep, and also show them how those human rights are being violated almost on a daily basis.
Exactly. Beautiful. That sounds like a great time to go ahead and stop the program today and the broadcast, and we will talk to you, next Wednesday?
That's right.
Okay, and we'll talk to you next Wednesday about how to protect yourself with the Universal Declaration of Human Rights. Operating as a private membership association and/or operating as just as simple as a person. It could be both, because the Universal Declaration of Human Rights covers all of it. And we'll show you how it relates between PMAs and people and lawyers and their associations and that association, and how it all comes together. It gets pretty interesting once you get into it.
Yes, it is.
So we will talk to you guys next week. Thank you for listening. Please pass this around to your friends and family. We do our listeners are growing every day, and we do thank you for taking time out to listen to this program. See you next week.
Have a good night, everyone.